Please, circuit court is now in session. The Honorable Judge Terrence Bennett presiding.
Please be seated.
Let's go ahead and do Hawkins first. Hold on just a second. Good afternoon.
Good afternoon, Judge. This is Rudy Harper on behalf of Rashad Hawkins before the court on 24 CF 411 and 24 CF 409. Judge, we're before the court on a pretrial detention hearing. Just need to advise the courts that I currently represent a co-defendant in Mr. Hawkins' case. I filed a motion to withdraw yesterday when I became aware of this particular case. Additionally, I believe that the state, and I don't want to speak for the state, but I think there's some issues that we may need to move this case, but I'll defer to the state on that.
The state would be requesting a one-time continuance per the statute for good cause. The good cause is I need to issue subpoenas for my witnesses. That way we can proceed with this hearing.
Very good. The court will continue this hearing until, what's next Thursday? February 29th. February 29th at 12:30.
Thank you, Judge.
Thank you very much.
Thank you, sir.
Any particular order? Which order you want to bring them up?
I believe Mr. Medina is speaking with a couple of his clients right now, so
You have one?
I could appear on Charles Emerson if
Okay,
we still
very good.
want my other client to go last.
Your Honor, while that defendant makes his way out, I believe
Hold on
that...
just a sec. Hold on. Sorry. Go ahead, counsel.
I believe that concludes my business before the court. May I be
You may.
excused?
Thank you.
Thank you.
Good afternoon, Your Honor. This is Charles Emerson, Emerson, docket 2024 CF 453, and I believe there was an additional docket added, 2024 CF 446. I've spoken with the state attorney, and I believe that they will be asking for a continuance as they would like time to speak with the alleged victim in this case.
Yes, Your Honor, that's true. I do have the victim's phone number, but I do need time to speak with them. I do believe the state will be proceeding with a pretrial detention hearing on this matter, but I do need to speak further with the victim and subpoena police officers and that victim to court next Thursday, Your Honor. So the state is requesting a one-time continuance, please.
Court will grant the one-time continuance till next Thursday, February 29th at 12:30.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. It's up to, I think the judge wants him to go last, so if I need to go next.
Do you have any others, Ms.
Your
Fargo?
Honor, I have Mr. Deshane, but I'm not
We'll
sure if
do
you want
him
to save
later.
that last.
Mr. Harper?
Judge, I have Brittany Chinchar.
Okay, let's do it. Chinchar.
She does have 2 counts. 50,000 on both.
Judge, this is Rudy Harper, present on Brittany Chinchar's case 24 CF 423. Judge, Ms. Chinchar is before the courts on a trafficking case. I believe 2 counts of that. In the state's, and I don't want to speak for the state, but I believe that they're amenable to a certain type of bond if the court is, were the court to accept it.
Yes, Your Honor, the state has reviewed the matter. I've reviewed the matter with my supervision. We do believe that a cash or professional bond with pretrial services would adequately protect the community in this matter. The state is requesting a $50,000 cash or professional bond on each count, Your Honor.
Judge, our response to that, Judge, is that Ms. Chinchar, she does have one history of the failure to appear, and that's noted in her record. And I think her prior criminal history is only one prior felony account. But with respect to the facts as alleged in the probable cause affidavit here, Judge, it's our position that at best the state has a constructive possession argument. Nothing was found on her person. It was found in a book bag in the vicinity of both herself and other occupants of the vehicle. She was not the driver of the vehicle. So we would ask for a $25,000 cash professional bond as to each count.
State?
So, Your Honor, as for Ms. Chinchar's criminal history, the score sheet that I have done shows that she has 4 prior possessions of controlled substance, 1 prior child neglect. She does have 1 prior failure to appear. She does have 1 other misdemeanor and 2 prior possession of prescription drugs without a prescription and 1 prior possession of drug paraphernalia. Your Honor, the issue in the constructive possession is a jury issue, not a probable cause issue. There is probable cause for this bond. The officers did believe that these were Ms. Chinchar's drugs. She was asking for feminine products, and the backpack were the feminine products she was asking for. So, Your Honor, the state and law enforcement do believe these are Ms. Chinchar's drugs and would ask Your Honor to impose a $50,000 cash professional bond on each count.
My only response to that, Judge, is that there's, at least pursuant to the probable cause affidavit, there's no indications that there are any personal property of Ms. Chinchar located in this particular backpack, driver's license, or anything of that nature. Feminine hygiene products are doesn't have her name on it. So I would submit that that's not really conclusive evidence of possession with respect to knowledge or awareness. And again, I would reiterate that this is a constructive possession argument, Judge.
Very good. Based upon the totality of the circumstances, not the least of which is the seriousness of the charge, this is a fentanyl trafficking charge, and as well as the past history and probable cause find, the court will grant the state's request for $50,000 cash or professional with pretrial services. Yes, sir.
Thank you, Your Honor.
Okay. Thank you very much. They already have their next hearings?
Thank you, Judge. Yeah.
Do they already have their next hearings? They have these? Okay.
Judge, that's all I have this afternoon. If I need an excuse.
You may be. Mr. Medina, you wanna?
I'm probably gonna get female inmate Dorothy Alexander, or
Very
my
good.
male is Michael Bryant.
Very good.
Female? May I proceed, Your Honor?
You may.
Your Honor,
Let's
Dorothy
wait.
Jean.
Wait.
Oh, I thought she was. We're ready.
Adjusting.
Apologize, Your Honor. Your Honor, C. Medina with Dorothy Jean Alexander approaching. Your Honor, her case is 24 CF 449. Is speaking with Assistant State Attorney Sharpless. The state is going to stipulate to her getting a bond, and we just need to have, in essence, a first appearance bond hearing. The state's told me its position would, out of the gate at least, was asking for a $15,000 cash professional. I note from looking at the paperwork, she has a total score of 4, which should entitle her to hopefully a signature bond, no FTAs, for instance. She is here in the local area, back since August to take care of her husband who's in the home. He apparently has MS, and it was important for her to be a caregiver. I explained to her that based on the nature of the charge and the alleged victim living in the home, there would very likely be a no contact and no trespass. That raises issues, Your Honor, if she will need to, at least temporarily, until and unless eviction proceedings are implemented, probably not be able to go back to the house except one time with law enforcement to pick up her belongings. Therefore, she's going to have to find temporary lodging. She's a person of not substantial means. She's asking for a signature bond. If the court is not inclined to give a signature bond, she's asking for cash or professional bond of no more than $5,000 cash or professional, so hopefully $500 that she could possibly get together. But again, that's really going to be a huge hardship because of her need to find temporary housing. The only other things I would add, Your Honor, and she could testify to what I'm talking about, but I believe she's 65 years of age. Based on her particular situation, her current responsibilities to take care of her husband with his MS, but she doesn't have Social Security until she's turned 66 in 8 months or thereabouts, so she really doesn't have an income right now. And by the way,
the victim was her husband, right?
No, Your Honor.
No.
The victim is her stepdaughter. My victim is here, and she does agree with her receiving a bond, but she does want to speak to you, Your Honor, when that's appropriate, just letting the court know that. The state's also requesting a mental health evaluation and treatment as a condition of bond, Your Honor.
That would also raise additional costs, Your Honor. I do just want to state for the record, obviously I reserve the right to cross-examine, but if taking the allegations At face value, this was a long wooden pole situation. There were references to alleged defendant, non-custodial statement of throwing a bat, but didn't throw it at the victim, so some sort of pole or bat appears to be part of the facts, Your Honor. I do believe a signature bond would, with conditions such as mental health
Is the
evaluation.
victim
treatment.
living in the home with the defendant?
I think that's the problem, Your Honor, is they were both in the home.
Your Honor, I was expecting for you to hear from the victim, but it's my understanding of the facts that Miss Williams had been gone and separated from the victim's father for quite a while, and then just recently came back into the home. I don't think all three of them were living necessarily in the house together, but I do know that the victim was the primary caretaker for her father while Miss Williamson was outside of the home for the last 18 months.
Your Honor, my understanding is Miss Alexander, who's my
Ms.
client.
Alexander, this is a formal court hearing, and I would ask you not to make faces and everything. Keep a straight face. Everyone's get a chance. If you want to talk, I'll swear you in, and you can talk away. But we're going to all behave. You might want to sit down too, counsel. Let's call your witness. Let's go.
Thank you, Your Honor.
It's a tight timeline today.
So the state's going to call Yolanda Williamson.
Let me go by first, okay?
Madam Clerk, will you please swear the witness? Please be seated. And ma'am, I can see you're soft-spoken, and I ask you to really, that's all right. Just talk right into that mic, okay, for me? There you go. Thank you. Go ahead. No. Wait for the question, ma'am.
I'll ask you some questions, Ms. Williamson. So, yeah, we need you to speak directly into the mic like this. So can you tell us what's your name and how is it spelled, please?
My name is Yolanda Williamson, YOLANDA-WILLIAMSON.
And do you know Dorothy Alexander?
Yes, ma'am.
Okay, and can you tell us how you know Miss
She
Alexander?
adopted me 3 days old with my father, who I take care of.
I'm sorry, can you repeat that? You are.
She adopted me 3 days old,
Uh-huh.
so she's my mother by written, my aunt by blood.
So, can you explain to the court, have you and Miss Alexander and your father been living in the same household?
No, ma'am. She left 18 months ago and then came back to the household after abandoning my father. So I became his caregiver for the VA and the state, his POA, and his sole caregiver other than the paid caregiver during the day.
So it's you that's been taking care of your father for the last 18 months, is
When
that
did
correct?
Miss Alexander return to the home?
She returned sometime in July. I can't remember the
July of what year?
of this year.
Of last year?
No, of this year. That just passed. I'm sorry.
Okay.
Yes, sir. I'm sorry.
Go ahead, counsel.
And do you believe that Miss Alexander does need help with some mental health issues that she might have?
Yes, ma'am. She used to take medicine for her mental health, and schizophrenia runs in our family. So I get mental health check regularly because it does, but she hasn't received any, nor has she wanted to receive any. I have given her my personal therapist, along with other therapy people to help her, but she refuses to get help, as well as using substances.
And if she were to have to do a mental health evaluation and any treatment recommended as a part of a bond, would that help make you and everyone else safer?
It would make us feel at ease if she's got on medication and got the help that we've been asking her to get.
And are you asking the court that Miss Alexander have no contact with you as a
Yes.
condition of her bond?
Yes, ma'am. I put in a restraining order this morning to ensure that for my safety and my father's safety.
Your Honor, at this time, I don't have any other questions for Miss Williamson.
Mr. Medina, do you wish to inquire of the witness?
Your Honor, I apologize. I was informed yesterday that there was a private lawyer, so I'm just, if I may have a moment, there is not a private lawyer. I'm the lawyer today, so I just need one moment to check something. Thank you.
Sure. He may have a couple questions for you.
Ma'am, you stated that Ms. Alexander has some mental problems. Is that it?
Yes, sir. She was taking Prozac the last time I knew it, but I don't think she's been on her medicine.
Okay. How old are you?
I am 33 years old.
33 years old.
July 21st, 1990.
Are you gainfully employed?
Yes, sir. I
Where
work
do you
at
work?
a storage unit. I would like not to say it because she will follow me, but it's written on my paperwork. I work at a storage unit locally
Okay, thank you.
as a property manager.
Okay. Nothing further, Your Honor.
Anything further, Ms. Sharpless?
No, Your Honor, the
Ma'am,
state
you
doesn't
may
have any
step
other
down.
questions.
Thank you. Is she excused?
Yes, Your Honor.
Okay. You may step down, ma'am. Anything else from the state?
Nothing further from the state, Your Honor.
Mr. Medina?
Should we go back to the podium, Your Honor? I wanted to ask a couple questions about her financial
Sure.
situation, not talking about the facts of the case.
Ma'am, you may come up to the
Come up
podium.
back, ma'am. Ms. Alexander, what is, Your Honor, can she be sworn?
Ma'am, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes,
Ms. Alexander, would you please state your full name?
Dorothy Jean Alexander.
And are you married?
Yes,
How long have you been married?
43 years.
43 years. And who are you married to?
Bernard Alexander,
And up until the time when you got arrested, where were you living? What was the address and where is that?
463 Old Post Road, Niceville, Florida, 32578.
And is that a subdivision, an apartment building? What is that?
My home, Blue Water Bay.
Okay, all right. And when did you come back to the area?
I came back and I left in May. I came back in August
Okay,
of this year.
okay. Do you have a financial ability to post, let's say, for instance, a $15,000 cash a professional? Do you have that kind of money?
I can get it together.
Okay, so you think you could get $1,500 to a bondsman?
And that percent of,
That would be $1,500 on a $15,000 bond. Are you saying you can come up with that?
we could talk about 500.
Okay, so you think you think 500 is feasible, but not 15,000?
I could do 5, but if I had to do 15, the
Okay,
100.
well, you're being honest with the court.
Yeah.
What about, do you have money to pay for a place to stay right now? Let's talk practically. If you get
No.
out, you're gonna have to get a motel or a hotel or someplace to live.
Right,
Do
but
you-
no, I don't, because me and my husband owned the house.
Okay,
She came to stay there in May when I left.
okay, that's enough on that.
Okay.
Do you agree if the court wanted you to get a mental health evaluation as part of your condition of pretrial release? Would you get a mental health evaluation if that's what the court ordered? Well, it would be part of the court order, or you'd go back to jail. Do you understand that?
But I thought it was something that she was asking for me to get, Ms. Yolanda, not the court.
Well, but the state's asking for it too. If the court were to impose it, is that a problem for you to go get a mental health evaluation?
And can I ask what the reason might be?
Ma'am,
for that?
okay, we'll move on. So you have very little money that's accessible to you at this point in time, is that right? Okay. Do you have a bank account?
And when I told you just gave back from up north, yes.
You do have a bank account?
Very little, yeah, I was saying that I didn't have anything right here, but yes, I do.
Okay. How much is in your bank account?
I don't know, it's been a while since I've used it.
Is that a joint account with your husband? It's your own bank account?
Mhm.
Do you have an ATM for that, or do you have to physically go to the bank?
I have to go to the bank.
Where is that bank located?
Okay, I haven't had my oxygen in a while, so.
Okay.
Eglin.
Eglin Federal Credit Union? Okay. All right. Your Honor, I don't have anything further.
Okay.
I'm asking for a signature bond in accordance with the recommendation. Thank you.
Hold on just a second. Based upon the totality of the circumstances, including, importantly, the lack of criminal background of this defendant, the court will issue a $3,500 signature bond. And as a condition of the bond, it will be important that there'll be no contact with the victim. And that will require that you stay away from the home. You're not going to be able, if she's living at the home at this point until this is resolved, not saying it's forever, but for the time being, this court is issuing a no contact with the victim order.
And Your Honor.
And pretrial services. I'm not ordering mental health eval at this point. That's something that we'll address as we go down the, as
Thank you, Your Honor.
we see what's going on down the road in this case.
Your Honor, I'm just going to go back and give her my card, if I may have your indulgence for a moment.
Okay.
Your Honor, because the husband has MS and lives in the home, she's allowed to have contact with him, but I don't, what also.
Yes, she is allowed to have contact with him. However, as a practical matter, there's the real problem because he's living in that home.
Right, so she couldn't, I'm just why I'm putting it on the record so she'll know. So for instance, is there a landline at that home? Do you know? So if you call that landline.
No, he has a cell phone just like I do.
Is he capable of answering the cell phone?
It depends who's there, if they would let him use the phone.
Your Honor, is she able to call her husband by cell phone?
If he has a personal cell phone, yes.
Okay.
She can call her husband.
Okay.
But you can't go near the home, ma'am, at this point. So,
Do I go get?
no, ma'am, don't.
Your
don't ask any
Honor,
questions.
can she have a one-time visit with law
Yes,
enforcement to
yes.
get her personal possessions?
Yes.
Okay, thank you. Would that be reflected, Madam Clerk? Okay,
It'll be
thank you.
reflected in the order.
Appreciate it, Your Honor.
That's good, it's a good.
Thank you.
Brian?
Your Honor, Steve Medina with Michael G. Bryant. He's here on a bond issue. I talked about this with Assistant State Attorney Giardina. In the state, I believe, is stipulating that there could be a bond in the new law case, which is, I think, 24 CF 353. Michael Gregory Bryant.
That is correct, Your Honor. The state is stipulating to a bond of $3,000 cash or professional with a no-contact order with the victim. It is the state's understanding that Mr. Bryant is already being held on no bond on his violation of probations.
Your Honor, just for the record, the BOP cases are 23 CF 2457 and 23 CF 1225. So we're not here in those cases, but only on the 24 CF 353. Your Honor, I believe you stated 3,000 cash or professionals, the state's request. Is that correct?
That's correct, with a no-contact order.
Okay, Your Honor.
State said stipulated. Is it stipulated, or is that the state's request?
That's the request.
Because stipulated means both parties.
That's the state's request, Your Honor.
Okay.
The nature of the stipulation was that he could get a bond, and it would be determined by the court.
Okay.
So, Your Honor, could he be sworn to discuss his financial situation?
Sure. Would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do.
Will you please state your full name for the record?
Michael Gregory Bryant.
Where do you normally live? Before you came to jail, where did you live?
Was staying in the extended stay
Okay.
hotel.
Is that where the alleged victim was located, or was she located at another location?
We were staying together from my understanding.
Okay.
I have a dog and my daughter. All I know is that she jumped on the bus.
Okay.
So I don't believe she's here to stay.
Okay. Are you able to pay a $3,000 cash or professional bond, which would, if you could get bond, would typically be 10% to bondsman, or $300? Could you pay $300?
Do not. We shared it was a bank account. All my money went to a Cash App bank account, which I don't have access to. So my last paychecks, I don't have any access to any of the money that I attained.
So you're asking for a signature bond?
Yes, sir.
On the new law case?
Yes, sir.
All right. Nothing further, Your Honor.
Your Honor, the state has no questions for Mr. Bryant. However, the state would just
Okay,
like to...
Let's just do the thing,
Okay.
and then I'll let you talk. Okay. Anything further? Mr.
Nothing further, Your Honor.
And now, sorry.
That's okay. The state would just like to add that the charge is domestic battery by strangulation. It is a violent charge. It's a violent crime. So the state feels that $3,000 cash or professional is a reasonable bond.
And what are the conditions? No contact with the victim, I
That's
assume?
correct, Your Honor. No contact with the victim.
Okay. Very good. The court will grant the $3,000 cash or professional bond with no contact with the victim, pretrial services, and you can't, I don't know where, does the victim have a residence that there can be no, because it was at a hotel, is the victim no longer there, or do you know?
From my understanding, that the victim contacted the state and left a message. We have not been able to get a hold of her.
Okay.
She stated that she is not currently in the state. That's as far as we know at this point.
So right now, there'll be no contact with the victim. What that means for you, sir, if you get out, is that you can't go within 500 feet. So if for some reason you ran into her, even if she walked up to you, you're in violation. And trust me, if you violate on that one, you'll be back, and they won't let you out. So just not trying to threaten them, just telling you straight up, stay away. It's your obligation to recede. Okay? Any questions?
Well, so I
No,
feel
that's your turn. I'm sorry, I shouldn't ask you that.
Yeah, it doesn't affect that. Thank you. Nothing further, Your Honor. Thank you.
Your Honor, that's all I have today. May I be excused?
You may. Thank you. Dylan DeShane. Now, the exhibits that were provided earlier to the court Are those copies, or should they be submitted?
Judge, that's what I was going to start with today.
Okay,
was,
I'm sorry.
No worries, Judge. First, I was going to start with, I've given a copy of the statutes that are applicable for today's purposes to the defense already, with highlights of what exactly the state's going to be looking towards regarding this particular case. If I may, Your Honor, I have a copy for you as well.
Okay. Thank you.
Judge, the next thing, as far as the items that Your Honor received this morning from myself and the defense, at this time, the state would ask that the items that the state provided, they were marked as state's exhibits 1, 2, and 3, that they be moved into evidence by stipulation. My expectation is the defense is going to be asking the same thing for defense A, which obviously the state has no issues with.
Yes, that's correct, Your Honor.
Very good. Based upon stipulation of the parties, the court will admit State's Exhibit 1, 2, and 3, and Defense Exhibit A.
And just to make the record clear as far as the procedure for today, Judge, I know we are present today for both case numbers 24 CF 388 as well as 24 CF 399. The state's arguments regarding Mr. Deschain's pretrial detention status is going to be based solely upon the 24 CF 399 case, which is the homicide charge. I can't argue to this court that it would be applicable to hold him with no bond on the battery charges in 24 CF 388, Judge. So I would ask, however, Your Honor, that throughout the hearing today that you keep in mind potential idea of bond for that case.
For the second case?
For technically the
actually,
first
the first
case.
case, correct.
Yes, Judge.
Okay, so you're proceeding on the more serious charges here, the
Yes, Judge.
homicide charges.
Yes, Judge. By statute, that's all that the state can proceed forward at this point as far
I
as the
understand.
request for no bond.
Very good. The state may proceed. This is
Thank you, Judge.
Judge Burton. Do you want to sit down?
Yes, Your Honor.
Judge, my first witness would be,
Do you wish to make any opening remarks? You're always welcome to do an opening. I'm not
Judge,
suggesting you do, I'm just giving you an opportunity if you want.
I feel like I've spent enough of the court's time for an opening
Very
is trying
good.
to set the stage. So, if I may, Judge, my first witness is going to be Detective Payne.
Madam Clerk, would you please swear the witness?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Counsel, you may proceed.
Thank you, Judge. Detective, can you state your name for the record, please?
Forrest Randall Payne, Jr.,
Okay. And where are you presently employed?
Niceville Police Department,
How long have you been there?
approximately 6 years,
And how long have you been a detective for Niceville Police Department?
4 years.
Detective Payne, how did you become involved in this particular case?
I received a call from Detective Ushery that he was responding to a disturbance that occurred at CVS in Niceville.
Where did you respond to first?
I responded to the scene at CVS in Niceville.
Okay.
Like the Sherman Williams, by the way.
And what did you observe when you arrived on scene?
When I arrived on scene, I saw an excessive amount of blood near a black Ford F-150 that was between Sherman Williams and CVS. At that time, the subject that was in the vehicle, who was badly injured, had already been transported to Fort Walton Beach Medical Center by EMS.
Were you able to identify that subject?
I was.
And what is the name of that subject?
Michael Ledford.
Were you able to speak with any witnesses regarding this?
Yes, ma'am.
Okay. Were you able to make contact with a man named Jonathan DeMastri in particular?
Yes, ma'am.
Okay. What did Mr. Demastri tell you about what he saw?
So he is an employee of Paradise Liquors that is directly next to CVS in the same Oak Creek Plaza. He stated that while he was working in the back doing resupplying the merchandise, he heard a commotion between two individuals, one being Michael Ledford and the other being Dylan DeShane. Afterwards, he went up front to see what's going on. The two subjects, Dylan DeShane and Michael Ledford, when he went outside, he observed both of them near a black Ford F-150 that was parked at the CVS. They were both in a physical altercation.
What did he say happened next?
The next thing he observed during the physical altercation, he did say it was MMA style between both. He observed Ledford pick up DeShane and toss him, and he did hear, "Are you done yet?" Michael Ledford told DeShane, "Are you done yet?"
Okay. What did he hear after that?
After he said, "Are you done yet?" Michael Ledford said, "Are you done yet?" Michael Ledford, he stated, turned his back to walk back to his vehicle. At that point, he observed DeShane get up from the ground and run towards Ledford while Ledford's back was still turned. At that point, they were on the driver's side of the pickup truck where he could not see anymore.
Okay. What did he say happened after that?
After a few seconds that went by, he observed DeShane run towards CVS, towards McDonald's Juniper Avenue, and the pickup truck started to roll as it was in drive, started to roll slowly, going over a curb. At one point, the final arrest was between Sherman Williams and CVS.
And were you able to observe any surveillance footage consistent with what Mr. Demastri stated to you of his observations?
Yes.
Okay. Where did you locate that?
Bell's Outlet, they have an indoor and outdoor footage.
The outdoor footage, is there any audio to that footage?
Yes.
And what can you hear on that audio?
So the first word that you hear the word pussy, and then the second word, is it okay if I say it is a racial slur? I hear nigga.
Okay.
And then in that footage, at the point you see DeShane start running towards CVS.
Are you familiar with Mr. DeShane's voice?
Yes.
How are you familiar with that?
After he was apprehended at the Cumberland Farms next to the police department, I was there, and he said nigga several times, and I could hear him. He talked spontaneous statements.
In your review of that outside footage, are you able to identify who made those statements on the footage?
Yes.
Who?
Dylan DeShane.
Okay, so in the course of your investigation, what happened next?
So in the course of my investigation, like I said, I arrived there. I observed excessive amount of blood everywhere. Mr. Ledford was transport EMS while I was on scene. Dispatch advised that a doctor from Fort Walton Beach Medical Center, where Ledford was, that he had passed away due to a laceration under his right armpit, possibly by a sharp-edged weapon.
In your investigation, did you see any signs that would indicate that Mr. Ledford was armed during this encounter with Mr. DeShane?
I did not see any signs.
Were you able to utilize any canine assistance in this case?
Yes.
Okay, and how did the canine help after Mr. DeShane was arrested?
After he was arrested, it is actually during that same, actually the next day, early in the morning, the 10th, February 10th, I asked Canine Sergeant Pond for Niceville Police Department if she could assist me in doing an article search with utilizing her canine, where DeShane was arrested, which is the Cumberland Farms next to the police department. And when she did do the article search where he was arrested, it led to the woods directly behind Pounders.
Can you explain for one second what exactly an article search, what that means?
Article search means the canine is used to find objects of what the canine handler asked for, I guess. I can't speak on that behalf of how that's trained.
Okay. I'm sorry, go ahead.
So when I was not there at this time, but I did request her, but afterwards she advised me what happened. She did tell me her K-9 Cody did lead her to a tent that was directly behind Pounders, which is also connected to Cumberland Farms next to the police department. That tent was on private property, which is Ruckle property. The tent, which she observed outside, was outside the tent, close to it, was a backpack. And inside the black backpack was a black hoodie with the logo Lakers on front. That same hoodie was seen when Mr. Deshane is in footage at Walmart on February 8th, as well as the Paradise Liquors footage. He's wearing the same Lakers hoodie.
And what's significant about this video footage from Walmart?
So, just real quick, so we can. So outside the tent were also 2 empty packages, Ozark packages, camping knives. Both were empty. The Walmart security footage shows him buying 2 Ozark camping knives.
When you say him, you're talking about
Mr. Deshane.
Okay.
Showing Deshane buy the 2 camping knives, yes.
Okay. What else did you find, or was found by Officer Pond of evidentiary value at that location?
So, again, the 2 empty packages. Later was found a sheath that was also outside that did belong to that same brand. Inside the tent was a knife that had blood-like substance on it, as well as another sheath. Outside as well, there was a box that contained the 2 packages, as well as a receipt from Walmart. On the bottom of that receipt were numbers from a gift card of sorts, pay card.
And were you able to trace that gift card?
Yes.
Okay.
So that gift card was also inside the tent. That gift card, the numbers on it matched the numbers that was on this receipt as well.
And is that the receipt generated from the video footage that you obtained from Walmart?
Yes.
Did you have an opportunity to go to the Fort Walton Beach Medical Center?
Yes.
Did you have an opportunity to observe Mr. Ledford?
Yes.
What injuries did you see?
I saw a large laceration underneath his right armpit. It was very graphic. A large laceration that looked like it was caused by a sharp-edged weapon. He also had a smaller laceration on the back of his head, and as well as just a bunch of abrasions as if they're caused from the ground.
Was an officer with Mr. Deshane at that time?
Yes.
Was he also at the Fort Walton Beach Medical Center?
Yes.
Okay. Did Mr. Deshane make any spontaneous statements at that point?
Not at that point, but at a later time when he was transferred to ICU, yes.
Okay. What were those statements?
The statements that were made so I did not show up to the hospital. I went to the hospital, saw Mr. Ledford. Deshane was intubated at that time. I left to drop evidence, but then I came back because advised he was about to be discharged. There was an officer there. His name was Officer Carlos Paveda, who was there as security. When I got there, Officer Carlos Paveda told me that Mr. Deshane mentioned to him once he
Objection, Your Honor. I'm sorry, I'm objecting now. I have an objection to the spontaneous nature of these statements.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
You may proceed.
Detective Payne, we were talking about the spontaneous statements that Mr. Deshane made. while he was at the hospital. Can you elaborate, please?
While Officer Carlos Boveda was there, Mr. DeShane mentioned to him, if I get out of these handcuffs, I'm going to run.
Now, was that night, that incident, was that the first time that Niceville Police Department had contact with Mr. DeShane during that week?
No, ma'am.
Okay. Can you explain the situation of the other contact?
So, February 7th, which was a Wednesday.
This was 2 days before this incident, is that
Yes.
correct? Okay.
2 days before the incident, we received 4 calls that involved him all in the same day. The first one was early in the morning. It was a disturbance that occurred at his father's house in the city of Niceville, which involved him, based off what the father said, he was belligerent, he was under the influence of alcohol, ransacking his apartment complex. When officers showed up, they asked him to leave, and he did. The second time, we received a call for a suspicious package, Skipper's Furniture, next to the coffee shop in Niceville, Florida. When officers arrived on scene, they observed Mr. DeShane. During that time, while speaking with Mr. DeShane, he asked an officer if he could slap him because he was homeless, had nowhere to go, and wanted to commit a misdemeanor act. That was the second time. After they asked him to leave, we responded to a third call back at his father's house. At that point, when officers showed up to that, he asked again if he could slap one of the officers. Because he was homeless and he wanted to commit a misdemeanor act for 3 hots and a cot. One of the officer sergeants gave him money to go to the bus and get a ride to Crestview, which is located near the Niceville Police Department where the pickup is. The fourth time, there was not a call generated. However, Lieutenant Kearns was at the police department. Mr. DeShane, per Lieutenant Kearns, Mr. DeShane came into the police department and asked Lieutenant Kearns for a list of misdemeanor charges or offenses so he can go to jail. And that was the end of that one.
Okay. During the instance with his father, was there any reports as far as how long Mr. DeShane had been in the area?
Approximately 2 weeks.
Have you had an opportunity to review Mr. DeShane's criminal history?
Yes.
And what can you tell us about what you found?
So in the criminal history, he did have all these charges occurred within New York City. He had several petty thefts and grand thefts, as well as a few burglaries. On April 21st, 2022, he was arrested for armed robbery with a deadly weapon and assault with intent to cause physical injury with weapon. On March 30th, 2023, he was arrested for robbery, threatened use of dangerous weapon. Robbery caused physical injury and theft.
Have you had an opportunity to locate any employees or employers of Mr. DeShane?
Yes.
In this area?
Yes, ma'am.
Okay. What did they tell you?
So he was employed at the Cumberland Farms, that is on Highway 85 and College Boulevard, next to the CEFCO, across the street from the CEFCO in Niceville, Florida. I spoke with the store manager that was there. He said Mr. DeShane was employed there. Start date was January 25th of this year. He had only worked there for approximately 4 to 5 days, and he was still employed at the time.
Full days?
Part-time.
Okay.
Part-time.
I'm sorry.
4 to 5 days, part-time. He was still technically employed the night of the incident, February 9th. During that time he was employed there, the store manager disclosed to me that Mr. DeShane was stealing items that are within the store. When I say stealing items, he explained he would grab snacks from the store, eat it, and not pay for it while working. Same thing with the cooler. He would drink, he said, alcohol beverages and not pay for it while still working.
Okay.
And as of today, he said he got the go-ahead to file termination papers on Mr. DeShane.
I don't have anything further at this time from this detective, sorry.
Does the defense wish to inquire?
Just a couple questions, Your Honor, if I
You may.
Good afternoon, Detective. Excuse me. So you were not present at the exact time of the incident?
Correct.
Okay. So you didn't personally see anything that happened that night?
No, ma'am.
All right.
You mean like the actual incident, correct?
Yes, correct. Thank you. And you didn't know about the incident until another detective called you in?
Yes.
Okay. And you took witness statements much later that evening, an hour and a half or so later?
The officers already started to spread out witness statements and talking to them. You have to speak with those officers.
Okay, thank you. Excuse me. You spoke with a witness who saw the beginning of the argument between my client and Mr. Ledford, is that right?
Yes.
The Paradise Liquor employee?
Yes, ma'am. It's going to be Johnson, DeMastry, because there's two Paradise Liquor
Yes.
employees that gave witness statements.
Okay. And he described how the incident between the two of them started?
Not how it started. He described he heard a verbal altercation up front, and when by the time he walked up to the front, they were outside, and then he went outside as well.
Okay. A gun was found on the driver's side of Mr. Ledford's car, is that right?
Correct, on the floor for the driver's seat.
Okay. And this incident happened just before 8 p.m.?
7:58 is what dispatch had down.
Okay. In a fairly crowded parking lot?
Yes, ma'am.
Okay. And then just one more question. Did any of the felony arrests in New York City result in convictions based on your review?
I cannot answer that because I'm still waiting results on that from that agency.
Okay. All right. No more questions, Your Honor. Thank you.
Thank you.
Detective Payne, the firearm that was located, was there any indication in your investigation whether that was involved in this incident whatsoever?
I had no indication that the firearm that was located was used. No indication.
Okay. Did you observe any brandishing of a firearm during your observations of the surveillance videos?
No.
Did you hear any threats in the audio of using a firearm in any of these surveillance videos?
No.
I don't have any questions.
Very good. Is the officer excused?
Yes, Judge.
You're excused, officer. Thank you for your help. Ms. Davis.
Judge, my next is going to be Detective Usry.
Madam Clerk, would you please swear the witness?
You swear or affirm that the testimony you have to give will be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you.
Please be seated. Talk directly into that mic, you guys. It's got very directional. Ms. Davis, you may inquire.
Thank you, Judge. Detective, can you state your name for the record, please?
Detective Stephen Ushery from Niceville Police Department.
And what's your job title there?
Detective.
And how long have you been employed with Niceville Police Department?
Almost 8 years.
How did you become involved in this case?
I was at the police department that night, going over some training with the shift. I heard the call come out as a disturbance at CVS.
What was the call described as?
Possible gunshot wound to a victim.
Okay.
I responded. I was the third officer from Niceville on scene.
On scene meaning where?
In between CVS and Sherman Williams in the parking lot at Oak Creek Plaza.
Okay. Please, go ahead.
So once I arrived, I noticed a black Ford truck up on the curb. I noticed a male gentleman on the ground. Two of our other officers were already on scene, Sergeant Travis Howe and Chris Fulford. Those officers were attempting medical care for the subject. He lost a large amount of blood at that time. It appeared his artery was spraying blood out of the right side of his arm. I watched Officer Chris Fulford try to plug the artery to stop the bleeding. It was a large amount of blood. Officers advised me there was a second location where they believe the incident started, where there was another large amount of blood located.
And how far away was that location?
It was a little bit farther, closer to the front of CVS, so the south side of the Oak Creek shopping plaza parking lot.
So within the same parking lot?
Yes, ma'am.
Okay. What else did you observe?
So at that time, I was there near that large pile of blood in front of Paradise Liquors, not where the truck was located. I observed a 99 Pickles small 50 milliliter bottle of alcohol near that. I heard from some of the officers on scene that they believed that somebody from Paradise Liquors had observed what had happened. So we made our way over there. I did inform Detective Sergeant Payne what was going on. He came out on scene to assist with the situation.
So what did you uncover as far as this 99 Pickles bottle?
So while talking to the clerks at Paradise Liquors, they did advise that Dylan DeShane had been in there previously, had failed to pay for that bottle and taken it with them. They showed me
Previously meaning how long before?
right prior to the fight.
Okay, I'm sorry, go ahead.
So they said that he failed to pay for that bottle. They said it would have been on his person, but I already knew I found that bottle out in the parking lot near the large pool of blood.
Okay. What do you do next?
At that point in time, we did receive a phone call from our dispatcher. They advised that a woman had called. 1 second.
Were you able to identify that woman?
I was not. I was just told by our dispatcher that her name was Jennifer Johnson from Massachusetts. So she had called to advise us that her son had just called and told her that he'd stabbed somebody outside a liquor store in Niceville. Wanted to know if that was important to us.
Are you aware of who her son is?
Dylan DeShane, but I did not know him at the time. No, ma'am.
Okay. How long did it take to locate Mr. DeShane after the call came out?
It was a couple hours later into the night, into the next day, technically.
How did that come about?
So once we got the phone number from Dylan DeShane, our police chief started speaking with him. One of our officers, once we got the phone number, one of our employees was able to get a ping search on the phone. We saw the ping was near Parton and Palm Boulevard. Sergeant Payne advised me it was my job to spearhead operations and locating and detaining Mr. DeShane at that point in time. During our efforts of looking for Mr. DeShane, Okaloosa County Sergeant observed him at that gas station at Palm and Parton. Run into the gas station, he barricaded himself into the restroom at that point, and then eventually was taken into custody there shortly after.
Were you able to participate in the apprehension of Mr. DeShane?
Yes, I was on the outside perimeter of the store during that time.
Did Mr. DeShane make any spontaneous statements after he was arrested?
Yes, he did.
Can you walk us through that?
Yes, and there's going to be some racial slurs in here. Is it okay if I read this?
Yes, we'd rather you be exact.
When asked if Dylan DeShane needed EMS emergency medical services, he advised his dislike of EMS to us. Then he stated, "That last nigga should have died, brah. He shouldn't have called EMS. Who is you fucking with people that get 3-year-old kids, brah? I pray to God I'm on this shit like 2 days later. I pray to God I'm on this shit 2 days later. I hope you get your shit recording, nigga. Fuck this shit. You should be there for your kids, nigga. It don't matter what it is." Dylan DeShane then went on to mention something about the law. I could not make out what he said at that time. Then he said, "I told my mom that too. She still believes in the laws. Y'all niggas fake as a motherfucker. I know I'm going to jail for murder, nigger. What's up? It don't matter what New York is to Florida. Murder is still murder."
So what exactly was Mr. DeShane's demeanor during this time?
He was playing around, laughing. He didn't seem to be taking it very seriously. He just did not appear to understand what was going on at the time, how serious of a matter it was.
Judge, I have nothing further at this time. Ms. Detective.
Does the defense wish to inquire?
No, Your Honor, I don't have any questions for this witness.
Is the witness excused?
Yes, Judge.
Officer, you're excused. Thank you for your help. Ms. Davis, anything else?
No, Judge, the state would rest at this time.
Does defense wish to call anybody?
No, Your Honor, no witnesses.
Does the state wish to make a closing statement?
Yes, Judge. Judge, we're here today on a pretrial detention motion based on 907.041, which I provided to Your Honor and the defense a few moments ago. So we're looking at, because this is a homicide charge, that the state can make a motion to ask for pretrial detention regarding this particular case. So we can look at whether there's a substantial, under subsection C, Judge, if there's a substantial probability based on the defendant's past and present patterns of behavior, the criteria in section 903.046, and any other relevant facts that any of these exist. And what we're looking to is subsection 5, that the defendant poses the threat of harm to the community. So at this point, Judge, we have a defendant that is charged with a dangerous crime as defined by the statute. He's charged with a homicide in this particular case. The state can purport to Your Honor that there is a substantial probability that the defendant committed such crime based on the testimony that we've heard today, as well as the probable cause affidavit that has been filed regarding this case. Now, the factual circumstances of this particular crime that indicate a disregard for the safety of the community, I think even the defense pointed out that we have an incident that somebody is armed and commits a homicide in a crowded parking lot with many other people around. So I think that's one point that we can start off immediately from the incident. He not only disregards the safety for the community at that point, but he also takes off running, does not stay on scene. It takes hours to locate him, where he is found barricaded inside of another public building. Well, private business, but open to the public. So, and it takes time to get him out of that location, where we have other customers that have been going in and out of that store. Now, the other thing that we can look at is whether there are any other conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. That's something that we can then look to this 903.046, the other statute, as far as the purposes and criteria of bail determination. And we can look at this list as far as what exactly this situation is and whether or not this particular defendant is going to appear for court. So again, we've talked about the nature and circumstances of the offense charged, and there also in the surveillance footage, you can hear obscenities being screamed by this particular defendant. The weight of the evidence against the defendant, we have pretty clear records showing this defendant buying the knives that were located from a canine track from him to this tent that he was residing in, with a gift card that was used to purchase these particular knives. This gift card is the same gift card that is the receipt that at Walmart it is seen that Mr. Deshane is the person that is buying the knives. We have testimony that this is a wound that is consistent with a sharp object that would be consistent with a knife that caused the lacerations to Mr. Ledford. So, and then we also have the defendant's confessions that he did this on the body-worn camera that was submitted to Your Honor, as well as in the jail call that was completed by Mr. Deshane to his mother. It's one of the things that I would point out about that particular phone call is during the course of the phone call, his mom says, you know, well, you just don't call your mom and tell her you just stabbed somebody. And the defendant just starts laughing. There's no denial, there's no nothing. We also have eyewitness statements as well as consistent video surveillance that all ties this particular defendant to the crime that's charged, Judge. No. As far as the defendant's family ties to the area, we are aware of, as Detective Payne pointed out, he does have a father that lives in the area. However, the father had called the police not once but twice on Mr. Duchesne in the same day. When he was asked to leave, he left and then came back later that day. And the police were called because of the defendant's behavior, because he was belligerent, because he was ransacking the apartment complex. The length of residence in the community, we heard from Detective Payne. He pointed out that in those interactions with the defendant's father, that Mr. Duchesne had only been here for approximately 2 weeks. That's consistent with the next prong that we can look at as far as the employment history, that he was only employed as of January 25th of this year with a gas station, not the same gas station that he was located in the day after the incident that he was barricaded in, but a different gas station with the same company, that he worked approximately 4 or 5 part-time days before he was stealing, and the termination is going through as we speak of his employment from that store based on his theft at the store. So the financial resources is the next point that we can talk about. You know, that again, we can look at the financial resources. He has none. He was clearly stealing to eat and drink, that he was living in a tent. We have very limited things that would tie this particular defendant to this area. We don't have somebody that owns a home, owns a car, owns anything that is going to keep him tied to the area. And then finally, on that prong is his mental condition. Judge, I'd ask that Your Honor take judicial notice of the pretrial services mental health screening that was done in 24 CF 388, where Mr. Duchesne represented that he has had mental health treatment previously. He is not compliant at this point, however. The next thing we can discuss is going to be the defendant's past and present conduct, including any record of convictions. Now, Officer Payne discussed on the stand as far as some arrests goes. I can represent to the court that this particular defendant does have a felony arrest and does have a felony conviction. In fact, he has a violation of his supervision for that in New York. I have the case number. It's going to be case number CR 02779622NY, Judge, with the New York Criminal Court. He actually has an upcoming court appearance on March 4th of 2024 regarding that case. So I think we do have somebody that has significant conduct issues that he would present a danger to this community. That's going to be really the next prong. We're talking about somebody that runs from the scene. The knife is hidden. He clearly has a lack of remorse from every point of interaction, it seems, throughout this process. So. Judge, the other point as far as the jail call goes that I wanted to make sure that we discuss today is in the jail call, there's a portion of it that Mr. Duchesne admits that at that point he wasn't crazy, he wasn't even intoxicated when this incident happened. So we have somebody that knew what they were doing when he stabbed someone with their back turned, going presumably to get back in his truck to leave. Nothing further, Judge.
Defense wish to make any closing remarks?
Yes, Your Honor. Your Honor, we're not here to dispute the seriousness of the charges. Rather, I hope only to give the court a slightly fuller picture of Mr. Deshane when you're making a bond determination. I'd ask that you set a cash or professional bond for the following reasons. Mr. Deshane has 0 failures to appear in Florida. In fact, he hadn't been arrested until this incident. There is no record of violence in this community. He does have the other pending case here in Florida, but it is stemming from the same incident. Though Mr. Deshane's only lived here for a short while, a few months at this time, he actually grew up in the area and spent most of his childhood here. His brother, sister, and stepmother all still live in the area. He moved back to the area to strengthen his relationship with his child. He was working part-time at the time of the incident. Your Honor, you have viewed and heard evidence prior to this hearing that I think paints, if anything, a fairly complex picture of the incident. Like I said, we're not here to debate the facts of the case, but I'm contending that this is anything but black and white. As for the jail calls, the defense contends that my client was not laughing out of humor. He was simply trying to make his mom feel better, as anyone would, speaking to their mother in this particular circumstance. You have seen in the video exactly why my client has every reason to return himself to court. You viewed the surveillance video from Paradise Liquors, which clearly shows the victim here physically pushing my client out of the store and punching him outside the store. I think when you watch the body camera footage, you're hearing incredulity and shock. I believe that the evidence here is serious, but it is murky, and I ask that you consider granting a cash or professional bond so that my client can clear the waters from the outside. This was an isolated incident, and based on Mr. Deshane's lack of failures to appear and the strong motivation that he has to return to court to handle the case, I ask that you consider a cash or professional bond. Thank you, Your Honor.
We have one moment.
Your Honor, if my colleague, Mr. Medina, can make an additional argument on the record.
Your Honor, the state, if I heard correctly, stated that there was substantial probability of proof, and I wanted to point out that appears to be based on recent statutory changes and is not consistent with the language of Article 1, Section 14, which refers to proof of guilt is evident or the presumption is great. That statute is very likely unconstitutional, and the state not only, I would just simply add that the state has not only not shown the constitutional standard for a bond denial, but doesn't even acknowledge the correct case law and the constitutional standard.
What do you believe the constitutional standard should be, counsel?
As is stated in the Constitution, and it's been interpreted by case law.
You want to put it on the record so the court can...
I'll have to grab the case, Your Honor. I apologize. I wasn't planning to play this role. May I have a moment?
Sure.
Thank you.
And then if you'll want to respond after he's finished, I'll allow that.
Your Honor, there is one kind of separate issue that I wanted to briefly raise about the motion to seal the arrest record. I'm not sure if you would like me to address that now or at a later time.
Later time.
Okay.
Your Honor, can I step outside and make a quick call to one of my colleagues? I'm sorry, I just did not bring that case law with me. I'm just not going to be able to predict, but I'm certain that the case law that is in existence and under that constitutional provision is more akin to greater than a beyond a reasonable doubt standard. It's not substantial probability. I just don't have the case with me, Judge.
So are you arguing that you're arguing that this statute, and I'm going to let the state respond in a second, but you're arguing that this statute is unconstitutional?
That is correct.
Okay.
And that the state has not met the burden of the actual constitutional provision and case law they're under, which I just can't put my hands on. I'd have to.
Okay.
Thank you.
Ms. Davis?
Judge, I believe that Mr. Medina is referring to the Arthur standard. This is not a motion requesting an Arthur hearing. We're not before the court on an Arthur hearing. So just to make sure that we're clear, the standard that Mr. Medina is looking for, I believe, to be the proof is evident and the presumption is great. Even still, if Your Honor asked that we argue that standard, I still think that with the testimony that's been presented today, the record that is before Your Honor, including the exhibits, we would meet that standard at this time, Judge. Now, the only other thing that I'm going to add as far as the defense's argument, Mr. Deschain's representation that he's here in order to strengthen his relationship with his child, I would ask that the court take judicial notice of the final judgment of injunction for protection against domestic violence with minor child in case number 21 DR 389. Your Honor is actually the one that ruled on this case and said that Mr. Deschain was not allowed to have any contact with the petitioner in that case, as well as the child in question. One thing that was interested of note, Your Honor pointed out in this that you were careful in what you were ruling because at this point the respondent had not done anything to establish his paternity regarding this particular child. So.
Very good. Thank you.
Yes, Judge.
You stand at the podium with the defendant. So, first of all, to address just briefly Mr. Medina's assertion or argument that the statute is unconstitutional, I'm not, based upon the information we have, the court does not find that the statute is unconstitutional. What I would say, though, is that because you may feel that there's additional information as it relates to the constitutionality, that's something that could be considered at a motion for rehearing and it would also give the state a greater amount of time to respond. That was kind of an unexpected argument. The court is finding, for the purposes of this hearing, that I'm denying the assertion that this statute is unconstitutional, and the court is operating under this statute. If this statute becomes unconstitutional or you make some argument later, we'll address it later. So, the court does find that I don't think it's surprising that the court does find that this clearly is a dangerous crime. pursuant to the statute. And based on that same statute, 907.041, the court finds that the court does find that there's a substantial probability based on the defendant's past and present patterns of behavior, including, and the court will lay out a little more detail, the criteria in 903.046. It does find that as a result of that, the defendant does pose a threat to the community, threat of harm to the community. And that the defendant is, as I said, was presently charged with a dangerous crime. And there's a substantial probability that the defendant committed such crime, and that the actual circumstances of the crime indicated disregard for the safety of the community, and finds further that there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to the persons. And the court considered the following, and these are the criteria that is used for this type of hearing in 903.046. Court did consider, obviously, the very serious nature and circumstances of the offense charged, being a homicide, and the court considered the substantial weight of the evidence against the defendant as allowed by the videos, the statements made by the defendant himself, as well as statements made by other individuals who witnessed portions of the interaction with the defendant and the victim. The court has also reviewed the family ties, finds that while there are some family here, they're not substantial family ties. That's pointed out pretty clearly because the defendant is homeless. He's only been in the community for a few weeks, has a short employment history, and has limited resources. The court has also considered the past and present conduct and any record of past legal actions. I'm not sure that we actually formally found convictions, but certainly there were arrests, and both the past and the present conduct, even merely surrounding this incident, would be sufficient to hold the defendant. But there are other things. Obviously, perhaps most importantly, the nature and probability of danger which the defendant's release poses to the community. Obviously, when you're dealing with a homicide and the death of an individual, there's no greater harm or possibility of danger than that. So, the court is granting the motion for pretrial detention. And I'll ask the state to draft the order.
That is as far as 24 CF 399.
Right.
And as far, with 24 CF 388, Judge, at this time, the state would request $100,000 per count based on the totality of the circumstances that Your Honor has heard today regarding the past and present history of this particular defendant and the crimes that were charged therein.
What are the charges in 388?
Judge, they're a battery on a law enforcement officer. Specifically, the allegation is that he spit in the mouth of one of the officers on scene.
Okay. Is that the only charge?
There's 2 counts, Your Honor.
Defense.
Your Honor, though my client is being held on no bond in the other case, I would ask that a lower cash or professional bond be granted. $100,000 per count on 2 third-degree felonies seems excessive. I understand the nature of the entirety of the circumstances, but we didn't hear anything today about those 2 charges. So I'd ask that
Well,
you.
it wasn't a formal hearing on that today.
No, of course
We're setting a
not.
bond, which in general is much more informal, and the court will handle those as it does all bond hearings. They are very
Yes, Your
informal.
Honor.
And if these charges were charges in and of themselves, perhaps they would be excessive. But considering the totality of the circumstances that we've heard today and received evidence on, the court does find that the pair of the $200,000 cash or professional bonds would be appropriate.
Thank
In
you, Your Honor.
addition to the pretrial detention. Okay, thank you very much.
Thank you, Judge. I'll prepare orders for both cases.
Thank you very much. Court's going to take a short recess. I know we are right on top of 1:30 hearings, and we're running late. The court's going to take a very brief break, and we'll come back and try and.
All rise, please.